and we should show up momentarily. Should be very soon. Okay, well, we are here. Hi, everybody. I'm Glenda Carroll. I apologize for my voice. I've had, I guess, a cold. It's not COVID, but I've been hoarse for a week. So anyway, I just want to welcome you to Mystery Writers of America, the Northern California chapter, and this is Facebook Saturday Live. This is a spot where authors have a chance to talk about the different factors of crime, and these are short, focused talks. Today, our subject is 6 things writers get wrong about criminal law. And to tell us about these 6 things is the person you see on the screen here, Michael Nava. He has 30 years experience as an attorney, and he's the author of the Henry Rios series. Now, Rios is an openly gay protagonist who is a criminal defense lawyer. Michael's going to tell you about his pet peeves that he sees on television courtroom dramas, and that he also finds in mystery writers' books who, sort of focus on crime. So if you've ever wanted to write a crime novel, a crime mystery, listen today, because Michael has some great advice. Now, if you have any questions, put them in the comment section on Facebook, and I will we'll talk about them once Mike's through with his presentation. So with that, I am going to give you Michael Nava, and I will disappear and show back up at the end of this. Michael, you are on.
So I will start by giving you a little bit of background about my career as a lawyer. I graduated from Stanford Law School in 1981. I was a prosecutor in Los Angeles for 4 years after that. I worked briefly in private practice at a civil appellate firm. And then for most of my career, I was a research attorney for the California appellate court system, which means I worked for judges working on their opinions. So I worked for the Court of Appeal in Los Angeles for a judge named Arlie Woods. And when I moved to San Francisco, I went to work at the California Supreme Court. I worked there for, in several positions. Among them, I worked for Carlos Moreno, who was a justice on the court. And when he retired, I moved to the death penalty staff, which was a staff of attorneys who dealt exclusively with death penalty appeals. So I have experience both as a trial lawyer, as a prosecutor, and also as an appellate lawyer. As a research attorney, half of my work was reviewing appeals in criminal cases. So I have a fairly broad and deep knowledge of criminal law and criminal procedures, although I haven't retired for 7 years, so some of it slipped away. A couple of years ago, I was a judge for the Los Angeles Times Book Award in the mystery suspense category. And one of the books that we looked at had been very well received. And it was by a writer of color, and I was very eager to read it. And it contained some courtroom scenes in a trial that were so preposterous that I told my fellow judges I couldn't possibly agree to allow this to be on our short list. So, given the vast resources on the internet about criminal law and criminal law procedure, there's really no reason that writers can't do a little research and get things right. I'm going to talk about 6 things that really annoy me when I'm watching TV shows about law, like Law and Order, or when I am reading mysteries, crime fiction that has trial components or involves the law in any way. The first thing I want to talk about is charging crimes. So charging a crime is the job of the prosecutor, not the police. You know, you will see on TV sometimes the police will say you're under arrest for, assault with a deadly weapon. And that doesn't mean that the defendant is actually going to be charged with assault with a deadly weapon. What that means is that based on the cops' observations and investigation, that's their best guess about the crime that has been committed. The arbiter of what crimes are charged is the prosecutor. And when I was a prosecutor in LA, one of the rotations I did was in the arraignment court, where we got police reports. We reviewed the police reports. We looked at what the arresting officers had arrested the defendant for, assault with a deadly weapon, which in California is Penal Code 245A. And then I would decide whether to charge that crime or a different crime, lesser crime, based on whether I thought there was sufficient evidence or could be sufficient evidence in the police reports to convict the defendant under the beyond a reasonable doubt standard. So often the cops would come in and they would want to argue, they would want me to charge whatever the crime was for which they'd arrested the defendant. And I would have to explain to them, this evidence, the evidence you presented me with isn't really sufficient to prove that crime. For example, in an ADW case, maybe there had been mutual combat between the defendant and the victim. The victim gave as good as he got. The defendant pulls a knife, doesn't actually use the knife. That's assault with a deadly weapon, because the knife would be a deadly weapon. And I would read the report. I would say, look, it's not clear who instigated the fight. The defendant could have been acting in self-defense. Both he and the victim, gave as good as they got. It's true that he pulled out a knife. He didn't actually use the knife. The fight was stopped before then. In this instance, I don't really think that we can prove beyond a reasonable doubt the assault with a deadly weapon. So maybe I can charge battery, or maybe I can charge simple assault. So I think it's important then, when you're thinking about if you're writing and the cop says, I'm arresting you for murder, that doesn't necessarily mean that murder will be charged. Again, the decision about whether to charge a crime at all and which crime to charge ultimately rests in the hands of the prosecutor. And that process is pretty, as I just explained, can be pretty inherently dramatic. I mean, there's some tension between the cops and the prosecutors often about what to charge. So, that's actually interesting and could be interesting in a novel. The second thing that really annoys me is when I hear or read, oh, that's just circumstantial evidence. Circumstantial evidence is not inferior to direct evidence, because virtually every criminal case is proved by circumstantial evidence. That is, evidence that tends to prove the defendant committed the crime, but where there is no eyewitness. So even DNA evidence is, unless there's an eyewitness, even something as seemingly persuasive as DNA evidence is only circumstantial evidence. In a rape case, for example, the defendant's DNA is found in the victim's body. Does that might establish that the victim and the defendant had sex. It doesn't establish in and of itself the defendant raped the victim. The sex could have been consensual. So in murder cases, murder investigations, unless someone actually sees the murder being committed, all the evidence tending to show the defendant committed the murder is circumstantial evidence. So my point is this: most criminal cases are proved beyond a reasonable doubt by circumstantial evidence, by evidence that tends to show that the defendant was the person who committed the crime and committed the crime. So when a character says, oh, that's just circumstantial evidence, as if to be dismissively, that's just nonsense. The only direct evidence would be, evidence of an eyewitness, and even, increasingly, eyewitness testimony has been under attack for some time now. There are now experts who are routinely called by the defense on eyewitness testimony who can establish very persuasively that we don't necessarily see what we think we see. And even DNA evidence, especially as it becomes more and more refined, has also been subject to criticism. So that's actually another area where I think that as writers, we have some responsibility to keep up with forensics. So, I think if you go and you read Elizabeth Loftus, who's the big eyewitness testimony expert, or read some of the new criticisms of DNA evidence, so that we're not just repeating the tired old tropes about eyewitness evidence or DNA evidence, because no piece of evidence is infallible. There's almost always going to be a way to attack or undermine or to cast it into doubt. And there are many kinds of evidence which have been thoroughly discredited. Bite mark evidence, for example, has been pretty much discredited. Even fingerprint evidence has been the subject of controversy. So it does behoove us as writers to try to keep up with the forensics if we're using forensics in our books. The next thing I want to talk about is appeal. Equally annoying to me is the character who proclaims after a defendant is convicted, oh, we're going to appeal, as if appeals were a retrial or a second bite of the apple. They're not. As I said, I spent most of my career as a research attorney for judges reading appeals, half of them from criminal cases. And I can tell you this, 99% of all criminal appeals fail, because an appeal is not a chance for the defense to relitigate the same evidence it litigated at trial. At the trial, the prosecutor is required to prove guilt beyond a reasonable doubt. So the burden is on the prosecutor. On appeal, the burden is reversed. On appeal, the burden is on the defendant to demonstrate that the jury that convicted him beyond a reasonable doubt did so erroneously. And ordinarily, to say, well, there wasn't sufficient evidence for the jury to have convicted me is just a loser argument, because the appeal judges are going to they presume that there was sufficient evidence. They presume that the jury came to the right verdict. They're not there to reassess the credibility of witnesses, for example, because they're dealing with the cold record, the text or transcript of the trial. And they're not the jurors who sat in the courtroom and who listened to the witness and who were in the better position based on everything, not just that they heard, but the witness's body language and so forth, to assess whether a witness was telling the truth. So on appeal, the appellate judges are going to assume that the jury properly found some witnesses were credible, others were not credible, and they're not going to second guess that. What appeals are for is for pointing out legal errors that may have resulted in an unfair trial. So, for example, you can claim that the judge impermissibly excluded some evidence. So sometimes the defense wants to present evidence that someone else committed the crime, which in the trade is called third-party culpability or evidence. That doesn't automatically get in. The defense has to lay some groundwork before it can present that evidence. It has to be able to demonstrate that the person who they're pointing at actually had an opportunity to commit the crime. But say a judge excludes that evidence, then on appeal you can argue, well, the judge erroneously excluded this evidence that someone else committed the crime. That's not an issue of credibility. That's an issue, that's an error of law. Did the judge apply the correct standards in excluding this evidence? Or you could argue the judge erroneously admitted some evidence. Ordinarily, for example, you are not allowed, if a defendant has been convicted of prior felonies, which the prosecution is not allowed to introduce that evidence to demonstrate that because the defendant's a bad guy who committed other crimes, he's more likely to have committed this crime. But say that the judge decides to allow evidence of prior convictions. On appeal, the defense will say, well, that evidence prejudiced the jury against my client because they assumed because he committed other crimes, he was more likely to have committed this one. Or there's some issue with the composition of the jury or the jury instructions. These are all legal issues, not factual ones. So don't have your characters say we're going to appeal as if that's going to result in a new determination of guilt. And do remember that if a conviction is reversed on appeal, it's usually on very narrow grounds and not because the evidence wasn't sufficient to convict. The next thing I want to point out is this, what I call the law and order fallacy from the TV program Law and Order, which is during a trial, during examination or cross-examination of witnesses, lawyers don't get to make speeches. And this is the problem I had with the book I was referring to earlier. In those trial scenes, the lawyers would go on for paragraphs, essentially, when they were examining a witness. And that just doesn't happen. First of all, if you're examining or cross-examining a witness, those questions have to be evidence-based, not speculative or rhetorical. So, and on cross-examination, you're limited to examining the witnesses only about matters that the witness testified to during direct examination. You can't prod in other stuff that wasn't part of it. If a prosecutor tried to make a dramatic accusatory speech while cross-examining the defendant, the defense attorney would object. He would say, Your Honor, there's no question pending, or Your Honor, that question is argumentative, or Your Honor, that question assumes facts that are not in evidence. You don't get to make speeches when you're examining or cross-examining a witness. You're really, and judges are very vigilant about this because those kind of accusatory speeches, those are argument. So yeah, now it's very easy to actually on YouTube or on court TV, if that's still around, to actually watch trials and to get a sense of the rhythm of the trial and of how prosecutors and defense attorneys ask questions. Now, of course, you're allowed some poetic license in that because most trials are, frankly, really boring to sit through. But what I think is not convincing is when a writer has a lawyer launch into a long speech, concluding with "Aha!" and you did it. So don't do that. And the last thing I want to talk about, which I've sort of touched on before, is that scientific evidence is not infallible, and that goes for DNA. So, the testing and analysis of forensic evidence is conducted by human beings who may be overworked at labs that are underfunded, using procedures that can almost always be challenged by an expert on the other side. This is what I call the CSI fallacy, which I know that a lot of prosecutors, particularly in the real world, have problems with them. In fact, they will tell the jurors in their opening statements, forensic evidence doesn't work the way it does on CSI. You don't have these immaculate laboratories with the latest analytic equipment and forensic analysts who only have one or two cases at a time to work on, so that they can devote their full time to a particular case. DNA does not, you don't get DNA results the day after you submit them. It takes weeks or months. If you submit a rape kit, you don't get the results of that the next day. That also takes a long time. And, if you pay attention to the news, there have been some quite notorious stories in the last few years about some forensic laboratories where rape kits have been sitting around for years untested. So again, we're allowed some poetic, license when we're writing about this stuff. So sure, have the DNA presented a week after have the DNA results given a week after they're submitted. That's fine. But it does, again, behoove us to have a more realistic view of how this forensic evidence is analyzed, and to read what the latest trends are in DNA analysis or fingerprint, whatever the forensic evidence you're going to use in your book. You should do a little research and see what the latest is on what's going on in that particular field. And these things, I think, tend not to weaken our books, but actually to make them stronger, because our readers want us to create plausible and realistic worlds. And the more that we can bring in, what's actually going on in the real world, I think the stronger and more plausible those books will be. So I guess that's it. Thanks.
Okay. I have a question for you, and I just want to remind anyone who's listening to put your questions in the Facebook comment section. But Michael, you've talked about some of the shows who, don't do as well as they should. Have you ever come across any TV or movie scripts or things that you've seen that actually do a good job of it?
Yeah, I mean, I was bagging on Law and Order, and it's true that the more recent seasons and the current season are they're ridiculous in terms of presenting a realistic view of what goes on in trial courts. But I'd say the first 2 or 3 seasons of that show, when Michael Moriarty was Ben Stone, those are actually pretty good on the law and pretty good on procedure, and their courtroom scenes tend to be more realistic. Also, as I told you, Glenda, when we talked last week, I've been watching the 1950s Perry Mason show, which I think I'm watching on Amazon Prime. And surprisingly, the first season of Perry Mason is also pretty good because it's based on the Earl Stanley Gardner books. And Earl Stanley Gardner himself was a public defender before he turned to writing. So those shows are surprisingly accurate in terms of what goes on in the courtroom.
Okay. One of the things that I was wondering about when you were talking about both DNA and fingerprints not really being foolproof. Everything that I've ever heard is that we have each an individual fingerprint. So how would that not be convincing evidence anymore?
Well,
How's that change?
because fingerprint analysis is basically looking at fingerprints. It's visual examination. They don't run fingerprints through some, machine to compare them. The comparisons are visual, and they're looking at what they call, I forget, something in ridges. Um, and so, and often you don't get a complete fingerprint, you get a partial print. So two experts visually examining the same fingerprint may come to different conclusions about whether it's the defendant's fingerprint. So again, we're talking about human beings doing a visual inspection and comparison, and based on that, coming to a conclusion. I mean, when I was trying cases, you would let the jurors take a look at the fingerprint evidence. So it's not rocket science. It's just looking at something and saying, yeah, this looks to me like these two things look to me like they're the same. That's basically what fingerprint evidence is. And so anytime you have that kind of visual analysis, there's going to be room for experts to disagree.
Okay. There's a comment here from Claire Johnson. And again, please pardon my voice. The DAs I know say that a huge factor in DNA evidence is how the DNA is retrieved and the protection of a suspect's rights. So you want to comment on that?
How it's retrieved, I'm not sure what that means. I do know that one big potential field of one fruitful field of attacking DNA is whether it was properly preserved, whether it might have been contaminated. And I haven't spent much time looking at this, but apparently they're using smaller and smaller trace DNA to identify people. The smaller the samples get, I think, the more vulnerable they are to being to the legitimacy being questioned. But yeah, I mean, DNA is still, I think, really the strongest forensic evidence, one way or the other. I mean, the Innocence Projects have certainly used it to exonerate people who were wrongly convicted. But my point was that the technology continues to evolve, both in its sophistication and its ability to find people, but also in its vulnerability to attack, and that it's interesting and profitable to us as writers to sort of keep abreast of the developments in that technology. And it can open our books to more interesting plot possibilities.
Excuse me. All right, so I have a question from Ted Haynes. Is it legal for the police to tell an arrestee that they have convincing fingerprint or DNA evidence when in fact they don't have it or don't have it yet?
The police are allowed to lie to suspects. So that thing on Law and Order is true. You can tell the suspect, yeah, we have your DNA at the scene, even if you haven't got the results in yet. That's not coercive.
Oh, okay. At the beginning, you were talking about when the police come in and so they make an arrest, it comes to you. If you, in your experience, didn't agree with what he's being arrested for, what's the response from the police, or what has been in your experience?
really unhappy about it. And it depends, actually, I have to say it depends because sometimes the cops themselves know that, it's borderline. That's like, it's like, to use a sports analogy, it's like pitchers, right? They want everything they throw to be called a strike, but sometimes they throw balls that they know are pretty borderline, and they're just hoping that the umpire will be generous in his assessment of the strike zone. So the Cubs are the same way. They present me with a case, um, and they would hope that I would charge the greater offense. But sometimes they knew that it was a ball, not a strike, and they would be okay with that. At other times, they would say, no, this was an ADW. You got to charge a guy with an ADW, and I'd say I'm not going to do that. Their recourse was to go to my supervisor. I mean, but honestly, the volume of criminal cases in LA is such that most of the time they would just grumble and um, accept my reluctantly accept my decision because they'd also understand that proof beyond a reasonable doubt is a very different standard than the probable cause that they use to effect an arrest.
Can you talk about that a little more, about probable cause and proof of?
So, to make an arrest, you have to have probable cause that a crime has been committed and that the person you've arrested has committed it. And that's a judgment call about the cops based on the evidence that they've been able to gather at the time of the arrest. It's a fairly low standard, but proof beyond a reasonable doubt is exactly what it sounds like. It's not just the defendant may have or probably committed the crime or even was likely to have committed the crime. No, it has to be the defendant. The jury have to be convinced beyond a reasonable doubt that the defendant actually committed the crime. So there's a big difference between probably committed the crime and committed the crime beyond a reasonable doubt. So the standards for arrest and the standards for conviction are quite different. And the best cops understand that and understand that the prosecutor has to be thinking ahead to trial and to what kind of evidence he or she is going to be able to present at trial and whether that evidence is going to persuade a juror that the defendant committed the crime beyond a reasonable doubt.
I was curious for those of us who may not have a law background and we want to include a courtroom scene, what do you suggest we go to verify what we think should happen? Is there anything on the internet that you would suggest, or a book, something?
The internet is full of resources. I mean, you can find everything on the internet. You can find jury instructions on the internet. You can find the California Penal Code on the internet. You can go to YouTube and you can actually watch criminal trials. You can go down to your local courthouse. Criminal trials are open to the public. You can go sit in a courtroom for 2 hours and be bored to death listening to a criminal trial. I bet you'll at least get a sense of what they're really like. Also, lawyers love to talk about what they do. So if you can buttonhole a prosecutor, I would say, just call a DA's office cold and say, I'm a writer and I'm writing a book and I want to include, I have some specific, it's better if you have specific questions. I have some specific questions about criminal procedure and, can someone talk to me about it? Yeah, lawyers love to talk about what they do, and I think they're fairly generous with their time. So I would encourage you to do that. And if you want to read a book where there's a fair amount of courtroom procedure, not necessarily a trial, read my last book. It's called Lies with Man. It came out last April. And in it, I have several scenes in a courtroom where there are motions. And there's a lot of discussion about legal strategy and legal tactics. So if you want to see how a lawyer writer handles the subject, read that book. And I know there are other lawyer writers also. So yeah, huge amount of resources on there in that.
Okay, I have another question from Ted Haynes. To what extent are police likely to not arrest a suspect? Because while they have probable cause, they can confidently estimate that the DA will never get a conviction.
If they have probable cause to make an arrest, they're going to make an arrest, because just as my job as a prosecutor was to assess whether I could convince a jury beyond a reasonable doubt of the offense that the cops had arrested the defendant for, their job is to arrest people, not to worry about whether the DA can prove it beyond a reasonable doubt. It's kind of a separations of power thing. The only instance in which a police officer might not make an arrest is where they're not convinced that they're not convinced that the crime has actually been committed. They don't have probable cause to believe the crime has been committed. Or let's say in the example I used before, they're called to a scene where two guys are beating the crap out of each other, and they look around and each wants the other arrested. The police are saying, okay, well, we don't know who the instigator was. You both pounded each other pretty well. Yeah, we're either if we're going to make any arrest, we're going to arrest both of you because we can't tell, and they'll both be charged, and then we'll let the DA sort it out. But if they have probable cause to believe a crime is committed, they really are obligated to make the arrest.
I'm interested in body cameras. When, as a prosecutor, do you get to look at the body camera footage before you say, yes, we'll go with this, or no, we won't?
Okay, so I was a prosecutor in the 80s, which was way before body cams.
Oh, okay.
I have no idea how that would be a good question to ask a prosecutor, whether the prosecutors review body cam footage. That's a very interesting question, Glenn. I'd sort of like to know the answer to that myself.
I'll go ask somebody.
Okay.
Any other questions? Okay, I'm gonna pop back on here. Thank you. Thank you so much, Michael. It was really interesting coming from someone who knows zero about, the law. My reference is TV, movies, and, things that I read. So thank you for spending some time with us. You may want to go back to the Facebook page, on the NWA Facebook page, because sometimes after we're finished, people will think of questions they didn't ask and they'll put them there. So, if you find anything, or if I see something, I'll refer it to you. But just take a look and see if any other questions pop up. So thank you for your time. This has been really interesting. And I just want to give you a heads up of what we're talking about next month, which is sex. And we're talking about those hard to write sex scenes. And maybe for you, they're not hard to write, but I've been trying to figure out how to get one into the fourth of the series of the books that I read, the Tricia Carson Mysteries. And I mean, it's like my parents are looking over my shoulders. I don't know what to do. So I'm very curious about this particular topic. So everyone, thank you for, again, listening to us on our Facebook Saturday Live presentations. And I will see you all next month. Again, Michael, thanks so much.
Thank you. Bye.
Bye-bye.